Commissioners of the Greater Boca Raton Beach and Park District is now called to order. It is Monday, December 2nd, 2019, and the time is 5:15 p.m. Joanne, would you please call the roll?
Sure. Commissioner Ernst.
Here.
Commissioner Engel.
Here.
Commissioner Rollins.
Here.
Commissioner Vogelsett.
Here.
Commissioner Wright.
Here. Commissioners, other than striking the first item of regular business per our executive director's request, are there any other changes to the agenda here? Okay, hearing none, it's time for public requests. Please step to the microphone. You may give your name and address, and we would enjoy hearing from you. Mr. Duquette, welcome.
Well, first of all, I'd like to wish everybody happy holidays here during the holiday season. And I'm very happy to see on your agenda you're going to have your decorum and your operating procedures for the meetings. One of the things I'd like to suggest is your typical Robert's Rules of Orders is you have the minutes, you have the old business and new business. And I have a copy of Robert's Rules of Order here off of Google if you'd like to look at that. And I can tell you that one of the things that was discouraging to see this agenda this week was that nothing about the golf course. I know I've communicated with Brianne, and that's going to be at the end of the meeting. But again, a lot of the people who have attended historically, it's definitely a sparse crowd tonight. But we've certainly been interested in knowing what's happened with the golf course. The city promised you something, and they strongly encouraged you to take a certain action. And so if they're not following through with their end of the bargain, it'd be certainly nice to let the residents know what's going on. Thank you.
Thank you, Robert. Anyone else? Greg?
Yeah, why not? Good evening. Craig Galanis, 1780 Southwest 22nd Ave, Boca Raton, Florida. I too would like to wish you guys a happy Thanksgiving and a happy holidays. First and foremost, I want to thank you guys. We lose sight of the fact that the effort and the hours over the last 2 years have been extensive. And know that we, as residents who've been involved, have many, many hours invested as well. And you guys put forth a very thoughtful and detailed plan, and you followed it right up until the city put their hand up and said stop, and they wanted to take this golf course over. And tonight, I want to urge you guys, those of you who are not supportive of continuing on with the plan and going this route with Price Fazio and Beach and Parks building our new golf course, I want to urge you guys to consider taking a few steps back, look at where we've been and how we've got here, and consider a thoughtful proposal to the city before the next joint meeting, which takes them through the history, which includes, them being supportive and signing off on the buying of Ocean Breeze, which they continue to bring up that was overspent for, but they signed off and supported it. When the golf course plan in general terms was presented to them, the last question of that meeting I was sitting in, they asked, would you be coming back for money? And the answer very conclusively was yes, somewhere between 10 and $15 million. Okay? From there, how we got to 28 million, or whatever the number is, was a mistake. And I think that somebody needs to fall on their sword and take responsibility for the process. Thank the city for helping us bring this into a reasonable budgetary figure, and hold your ground. This is our golf course. This isn't the city's golf course. This is our money. This isn't the city's money. I don't want to hear another city council member say this is our money. It's not. This is the taxpayers' money. You guys were elected to do a job. You've done an outstanding job to date. and should be proud of the effort that you've made. And there's no reason whatsoever to turn back and put your head down with your tail between your legs and hand this thing off to the city. We have no confidence in their ability to give us what we've told you guys that we want. Okay, we sat in those meetings for 2 years, provided community input to you guys and Price Fazio. They get it, they know who we are, they know what we want, and to begin that process all over again is not only disrespectful to you guys, but it's disrespectful to us, the residents of the city of Boca Raton, who've spent countless hours to come up with what we believe is a wonderful plan for our new golf course. So representing the Boca Golf Association, if it means walking away from the table and letting the city deal with the repercussions of no golf course moving forward and sitting on the land, then so be it. They're taking $67 million out of our pockets that was earmarked for recreation, and Lord knows they won't even answer the question what they intend to do with it. So be strong, hold your ground, and please continue to support the plan that we have spent 2 long years developing. Thank you.
Thank you, Greg, and thank you for all your support. Okay, Rick.
Hi.
Hi.
Thank you, Commissioners, and I echo, I think, everything that Greg just said, but I wanted to talk about something completely different. I didn't make the last meeting, and I watched the video. Oh, excuse me, Rick Hurd, 285 Northeast Spanish Court. I watched the video from the last meeting, and I wanted to pick up on the topic that Commissioner Engel brought up about the future of the district. Because I listened to that and I took that to heart. And I think you should be concerned for 2 reasons. I wasn't around, actually I was around, and I was probably in Boca at the time in, I think, 1974 when the district was formed. And I believe that it was formed to help those who didn't live in the city have a way to enjoy the beaches and the parks that were being built. And I also believe that when the boundaries were determined, there probably weren't 20 people who lived west of the Turnpike. And the boundaries were put to the Turnpike. And that's obviously not the case today. And over time, the difference between the district's boundaries and the city's boundaries the differences between those boundaries have shrunk as the city has annexed. And I think you risk becoming irrelevant, and I think you should be concerned for your future. I think you should strive in every way possible to make sure that those who live in the district, and I'm not one of them, and not in the city, know what they're getting for their taxes and it's worth it for them. And I believe that you should work to expand the boundaries of the district as far as greater Boca Raton area goes west of 441. Because I think that all of those people enjoy the same parks that we enjoy. They enjoy the same beaches. They should have the same amount of responsibility for paying for those as we do, and it should be worth it for them. They should be considered residents for the purpose of the uses of those parks. And I did a little miniature analysis because I'm one of those quantitative guys that like to play around. And I believe that the current millage rate would probably be about half of what it is now if you were to do that. And it would spread the costs of the beaches and parks across those who truly use them in the greater Boca Raton area. Thank you.
Thank you, Rick. That was interesting. You were always good with the numbers.
Oh, you know what? There was actually one other thing. And looking at the statute, the more costs are paid for by the city, the more irrelevant you become. And so when the city reaches out and says, don't worry, we'll pay for DeHernley Phase 2, that's not a good thing for the district. And when the city says, oh, don't worry, we'll take care of this part of Gumbo Limbo, or we'll step in and pay for the golf course, that's not a good thing for the district. Because your purpose is to fund those activities and to reimburse the city for its beaches and park activities. And the more that they take over in payment or anything else, the more irrelevant you become. So anyway, that was it. Thank you.
Thank you, Rick. Steve?
Yeah, just, as a point of information, I was under the impression that the original Beach and Park District boundaries extended west of the turnpike.
I don't think so.
I had heard that, Steve, but I don't know when it was finalized, whether that was actually the case, maybe that was the intention originally, but as long as I've been here, I don't know the history beyond the fact that where we are today.
Okay.
I have the definitions here as turnpike,
There was turnpike,
the legal definition of the property.
perfect.
Yeah, but I think originally, Rick, there was some talk about taking it beyond the turnpike, is what Steve was saying.
Yeah,
It was finalized.
I was under the impression that the original boundaries, under the original enabling legislation, went out past the turnpike. I might be wrong, matter of fact, I'm a married man, so chances are I am wrong. But something worth looking into. I think your idea has merit.
Okay. Would anyone else like to speak? Hearing none. Public requests are now closed. It's time for the approval of the regular meeting held on November 18th, 2019. These minutes are found on page 2 of your agenda packet. Do I hear a motion?
So moved.
I'll second.
Is there any discussion?
Steve, just for, hang on 1 second. I noticed on the agenda packet they were signed, and I think that was erroneous.
Yes,
Okay,
that was my doing. I put the packet together and that's why Joanne does it better than me.
Okay.
So I apologize, I grabbed the wrong ones when I combined it into one.
no problem. So we're approving a,
They're not approved yet.
okay, correct.
Okay. Are there any other comments, commissioners? All in favor of approving the minutes, please say aye. Opposed, like sign. Motion passes, Joanne. Okay, now we come to our regular business, the approval of the retirement plan, found on page 6 of your agenda packet. Brianne?
I keep forgetting to order another one. Okay, page 6 of your agenda packets, it talks about the retirement plan. We need to approve these resolutions so we can enact it. I gave you guys a copy of it a few meetings ago, and I just handed out a table, a matrix and it's highlighted in red. The plan, as it stands right now, would be a matching up to 5% for the executive level staff. It does allow, if we were to hire other employees, whether they're part-time or full-time, that they could contribute to their own, but the district itself would only be contributing to our 3 positions right now. And the table kind of shows you where that's at. If we were all to put in 5%, the max contribution from the district would be that highlighted number in the red box. But we have the resolutions are just blanket resolutions that we need to read in and get approval tonight if everybody's ready to move forward with it.
Would council like to read? Oh, Bob,
Just
sorry.
one question. I assume, Brianne, that you've checked with council as far as being able to bifurcate a plan like this so that it's not considered discriminatory.
Yes, we can set it up any way that we want as far as our staffing goes. And there is an option with the 457B that gives anybody the ability that we hire, whether they're part-time or not, to contribute at least to their own retirement.
Right, thank you.
Madam Chair?
Jacob, would you like to read the
I
resolution?
I have
Okay,
one quick
Steve.
question. Beyond the 5%, is there a provision down the road at some point, say for matching 50 cents on the dollar for any additional contribution the employee might make?
I think most of it's set up as a percentage. We can change it in each year. We have the option to, I don't know what's, everything's been wrong here. We can change it each year, and you can change it to pretty much anything you want. I don't know if they do $1 per se, more, it's
Well,
usually a
50, in
percentage.
other words, if, say you did 7%,
Mhm.
okay, so you get the 5% matching plus an additional 1%, because you would be contributing 7, and the district, after 5, would only be matching half, so that would be 1.
I see what you're saying. Yeah, we could certainly set it up that way in the future if that was
Okay.
something we wanted to do.
That's all I need to know, thank you.
Any other comments? Okay, Mr. Horowitz, would you read Resolution 2020?
Thank you, Madam Chair. Resolution 2020-02 is a resolution of the Board of the Greater Boca Raton Beach and Park District establishing a defined contribution and deferred compensation plan, providing for execution of a trust joiner agreement. A copy is attached to the resolution included in your backup, providing for the adoption of a defined contribution plan and a deferred compensation plan, providing for acknowledgement of master trustees, providing for execution of an adoption agreement, providing for abiding by terms and acceptance of services, providing for termination of participation, providing for acknowledgement regarding assets, providing for approval by master trustees, providing for full force and effectiveness, providing for repeal of conflicting resolutions, and providing for an effective date.
Thank you, Mr. Horowitz. Commissioners, do you have any questions or comments? Okay. And do we have another resolution?
We need to make a motion on this resolution.
Yes, you do.
I move for approval of resolution number 2020-02.
Do we have a second?
Second.
Thank you, Mr. Engel. Commissioners, any comments? All in favor of approving motion 2020-02, please say aye. Opposed, like sign. Motion passes, Joanne.
There's just one resolution and two agreements. Can we make one motion to approve the two agreements?
Both agreements were included as part of the resolution.
Fine, we're good.
Okay. Our next item is the public decorum policy found on page 13 of your agenda packet. Leanne, would you like to start with that?
Yes. Page 13, at our last meeting, we talked about public decorum and putting some meeting rules and some structure in place for our meetings. And it was directed that I go through the city and see what they have in place. So I did go through the city's municipal code. And what you see here was kind of adapted from that code to fit our purpose. And I know Jacob and Sam have read through it and they have some input as well. And I think they have some recommendations for this moving forward tonight.
Madam Chair, if I may, this is a very good start in the right direction. I think it's certainly a document that, given the nature of our knowledge of local government process and procedure, that it certainly gets you to a better place. But I recommend that you consider this evening to adopt it in principle. We can then listen to any comments you may have, or between now and the next meeting of the board on the 16th of December, you can bring back a revised document with some more refinements. For example, although it refers to the disruption issues during public meetings, there's a statute in Florida which we cite to in other local government regulations and policies that basically suggest that it enables under state law for a police officer, for example, to regulate the behavior if you were to call upon an officer to remove somebody from a meeting, for example. The law basically rubs both ways. I must confess this to you on the record. It doesn't apply just solely to a speaker at the podium who's disruptive. It could be one of your own colleagues who's disruptive. It may sound to be not a sorts of conversation, but not here, and this is a very civil organization, but there are some other organizations which are far less civil than you are and have become very disruptive during public meetings, which require some recessing or some other behavior that needs to be regulated. We would suggest that you consider the policies this evening, even adopt it by motion and direct us to finalize between now and the next meeting. But there are a couple of refinements that we could offer up that might be useful between now and December the 16th.
Thank you, Mr. Gorin. Commissioners, do you have anything to add to this? Do I hear a motion to adopt the meeting rules of procedure in principle and to suggest that council revise some of the points of this?
So moved.
Second.
Any discussion? All in favor, say aye. Aye. Opposed, like sign. Motion passes.
Thank you, Madam Chair. Just for the record, I think you should know that this is a very good first start, and I compliment Brian. We both do, Jake and I, in the context of how this was organized. Brian didn't just take a document off the shelf. She actually looked at the Boca Raton model. She looked at several models we gave her, and she, in a lawyer-like, non-lawyer-like approach, kind of melded the two concepts to get to a document that is designed for this organization, and it's done so very well. So thank you for your input. And by the way, if you have any comments after the meeting you may want to offer to us independently, feel free to do that as well. Thank you.
Thank you, Mr. Gorin.
Yes, ma'am.
Some of the other discussion at our last meeting was about a policy for contractors and vendors, and the ideas that we discussed between Sam, Jacob, and myself was that we would put an addendum on future contracts and for future vendors that they would sign off, that they understand that there's no harassment of staff or commissioners, and write that up and with some direction, we can have them put that in place, so any future contractors sign off on that when they come on board with us.
Definitely.
Good idea.
Okay, the approval of the Ocean Breeze debt service payment found on page 17 of your agenda packet. Yeah,
That payment is due, so we just wanted to get it out there, get it approved, and send them over their money for the Ocean Breeze debt service.
Craig, did you have anything to
Is
add
there
to
any
that?
reason why we have to carve that one out specifically to approve it versus including it in all the other debt payments?
We just did so that everybody's aware that we're making the payment, just for the purpose of putting it on the record.
Okay, but going forward, is it,
We've done that with a lot of the city invoices, just having it separate, so that if anybody has any questions about the bills or the payments, they can ask them at that point.
okay, so is that gonna be our practice going forward? Because I don't remember when we had
Last year when we did the debt service, we did separate it out, so that's been the practice.
yeah, I guess I'm just trying to say, if you wanna, we also pay $1 million plus, on a quarterly basis, or monthly basis.
We
To
don't-
me,
We don't have to, we were just following what we've done in the past, last year.
I mean, the reason I mention it is, to me, it's a contractual obligation to the district, so
Agreed.
I'm kind of done with it once, I just want to make sure that we pay. So, any thoughts?
I feel the same way Craig did.
Okay.
Quite honestly, just put it in there as a lump sum for interest and the payment and be done with it.
We'll do that moving forward then.
Okay.
Mr. Gordon, do we need a motion to adjust that?
It's on the invoices.
It's on the invoice.
It's on the invoices, okay. All right. Walkway repaving?
Commissioners, when we approved the budget, we approved a project for walkway repaving. We have root protrusions at Patch Reef and Sugar Sand Park. So in your packet, starting on page 18, Melissa found a contractor that has a state bid, and Jacob and Sam have reviewed it, and the prices are consistent with the Palm Beach County. They are over our 5,000 threshold, so we have it before you tonight for approval. And if you have questions about the project, Melissa can answer them.
So we're conferring, we apologize.
Okay, go ahead.
And the question was?
Nothing, just if they have any questions about their project for the paving. We need approval for the purchase orders.
Just to be clear, we also, item number 4 was approved by motion, correct?
No.
No.
Okay, we were going forward with the approval of invoices, since it was part of the invoices.
Well, I mean,
Just to
since
clarify.
it's on the
It
agenda,
is.
I'd like to make a motion to approve the debt payment, and then going forward, have future debt payments included in the invoices as it is tonight.
Second.
Thank you for the clarification, because I sensed that was what the motion was, but I didn't hear it, and I apologize for not interrupting in a diplomatic way earlier, so.
That's fine, thank you for bringing it up. Is there any discussion? All in favor, say aye. Aye. Opposed, like sign. Motion passes, Joanne. Okay. Does anyone have any questions for Melissa about the walkway paving? Okay, hearing none.
Well, I guess
Okay, Craig?
we can't let her off that easy. Melissa, is this, I understand all in favor of doing it, is there anything else that needs to be done? I mean, far as the walkways go before they do it, specifically I'm thinking about the tragedy out at Boca, where trees need to be trimmed and stuff like that. So if you have tree roots going underground, there's probably something above ground as well. Is it a better time to do a little tree trimming as well?
Well,
before-
yes, sir, I called a company today that I had gotten from Greg, a company that they uses to come out and take a look at the 3 corners at the golf course and to evaluate the health of those trees and then to provide us a quote for trimming the trees as is. That would be a separate contract from this because this is simply an asphalt company, they won't handle that. But the sidewalks there are in pretty good condition. I have not seen any cracking and root intrusion on their sidewalks. These are, the sidewalks here are at Patch Reef Park after walking all of them last year. These are the ones that I evaluated to be in the worst shape from a root intrusion standpoint. And that was from Patch Reef Park Tennis Center up to the loop at the entrance.
Right.
And that's probably the worst one we have, and there's a lot of people go out there with strollers and stuff that try to jog that. So this will help a lot. And the other areas from the field house to the tot lot at Sugar Stand Park, and then also from the quad set of baseball cages to the quad fields at Sugar Sand Park to the dual fields or duplex it. And then the last bit of it
The
is,
duplex being the field house?
the duplex is the set of 2 fields. So there's the quad
Yes.
fields that's set back from it, and the city has called them duplex, so. And that area, so those are the areas that this all involves, covering and doing the root intrusion
So
now.
what I'm more concerned about is, fully on board, I was just thinking that because there's root intrusion on the paths around at Patch Reef and at Sugar Sand, would it make sense to have an evaluation, just look at what trees above, to do the tree trimming before you do the installation of the road work, because then they put these tractors and stuff like that, dropping stuff, and they don't care about new asphalt.
I'll take a look at it and I'll work with Greg on it. I mean, they do a pretty good job in these areas of keeping those trees trimmed up, but I will definitely, absolutely take a look at them.
And lastly, I think there is a pathway from the quad complex to the parking lot going towards Fieldhouse that is asphalt that was kind of rough to go
I
through.
think that's the one from the field house over to the tot lot, which is the quad fields. So that's included in this.
Okay,
It's that little playground right there by those quad fields.
that's right, that's
Yeah.
correct, yeah.
That's
That's the one, okay.
included in here. Yes, sir.
Question, I thought I saw something here regarding, a root barrier to the asphalt. I know we've done that before, where they've gone in and, actually, I guess have cut off the roots so they don't extend underneath the asphalt, and then put a barrier there to prevent them from growing back through underneath the asphalt. Is that not possible?
They will do that in certain places. A lot of the places, especially at Patch Reef Park, the gentleman told me the roots are so big that they can't do that or it would kill the tree. So in the instances, they'll go back and shave them down as low as they can go and get it so you don't have that intrusion anymore. But the root is big enough in those particular areas that if they cut that root, then it will kill the tree.
We don't have any more right-of-ways that the power lines, if P&L's gonna come down and cut our trees.
Not that I'm aware of.
All right, because they're pretty savage when they get underneath those trees, as we've seen on the Clintmore Road.
Absolutely.
The total of all 3 years, $80,195.50.
So the total is 80,000,
$195.50.
and do we have it budgeted?
We do, we approve this.
Okay,
210,000 was budgeted.
perfect, okay.
Good job. You need a motion?
Yes, we do.
Then I make a motion, we accept the bid to do the asphalt paving as the amount of
$80,195.50.
$80,195.50.
Second.
It's a two-part element.
Thanks, Steve.
Steve got it.
Is there any more discussion? Any comments? All in favor, say aye.
Aye.
Opposed, like sign. Motion passes, Joanne.
Thank you.
Okay. We now have our last item of the Sunshine Law presentation, which is long in coming, and we thank Mr. Gorin and Mr. Horowitz for having patience with us.
Thank you for being patient with us too. Good evening, everybody. Nice to see you this evening, and we appreciate very much you spending a few minutes with Jake and I to kind of go over a couple of things that perhaps you have come accustomed to because of your experience and your background and your attendance at meetings, but also because of the fact that you've come to watch other public meetings and how they're conducted and how they're actually facilitated during the course of time. A couple of observations just to open the door for you. There's a booklet which you probably have not seen before. If you have, I'm going to remind you of that. Have you ever seen this book before? Okay. This is the Florida Sunshine Manual. It's the Government of the Sunshine Manual. It's published by an entity called the First Amendment Foundation. It's the 41st volume. This is volume 41. It began 41 years ago, at a time when I first came to Florida back more than 41 years ago. But I must confess, this used to be a brochure. Literally used to be a pamphlet with regard to the statute governing sunshine and public records, and the backup of which was really very limited and very brief, as the case may be. This book has actually progressed dramatically since its inception. If you don't have one, we should get you one. We should be on the mailing list from the First Amendment Foundation to get you these booklets. It may seem like boring, difficult reading and something you wouldn't choose to do and to read, but I will tell you that in our collective experience in recent years, this document has not only become a source to help public officials elected and appointed, but also it's a source for courts to review. So for example, aside from the Attorney General's opinions and the citations of cases that occur in the back, it's very common for courts of law to actually look at the Sunshine Manual as a basis for their decision-making. They will actually look at the commentary, they'll look at the analyses, they'll look at the measured discussions, and will ultimately come to rely upon this particular book. How do I know that? Well, I know that because we've gone to court over issues such as this. This past year, I had the pleasure of being up before a grand jury twice in Broward County with regard to Broward Health. I was general counsel for 6 years as the outside-inside counsel, and that grand jury returned several indictments against their appointed officials and their lawyer. The appointed officials were charged with sunshine violations specifically, and the lawyer was charged with conspiracy to commit sunshine violations, which is a charge we've never really heard of before, but to the extent that it was offered, it did occur. And to the extent possible, the court looked at this manual as a source, and the grand jurors had copies of this in the grand jury room. I can't go into any more detail about what was discussed because that transcript is sealed. Both are sealed. The indictments were returned. They were all charged. The judge locally in Broward County dismissed the charges. The case is currently on appeal in the 4th District, FYI. But this document was a source document for the grand jurors to review, and was a source document for the court to review as well. And it was cited to, by the way, in the various briefs filed by the lawyers involved in the case. So it's worth your knowing about it, it's worth reading. Even if you read one chapter every week or two, just to kind of get a gathering for what it is. But the reason that we're here to talk about the subject matter is, what is the Sunshine Law? You've heard about it, you've discussed it, you've debated it, you've had some conversations about it. But under the state of Florida, it is a constitutional provision. It is in the Florida Constitution. I'm not making this up. This is actually in the Constitution. It's not Article 10, it's not Article 25, it's Article 1, Section 24. It is in part of the Florida Constitution, adopted back in the late 60s, early 70s specifically. So the origin of the Sunshine Law is the Florida Constitution, which later became part of the Florida statutes. What is the Sunshine Law itself? So when you hear about the Sunshine Amendment to the Florida Constitution, what that's telling us is that there's a provision in the Constitution, Article 1, Section 24, that governs both sunshine and public records. It's in the same section. And Jake will talk about public records in a few moments, but at the end of the day, it's a constitutional provision which created the Sunshine Law, Chapter 286 of the Florida statute, 286.011 of the statutes. It's a very small statute. It's maybe 4 or 5 pages. So when you look in this manual, for example, you'll find that it's cited to, and it's a very small portion of the actual statute books themselves. There are several components of 286.011 which I think are very important to understand. First of which is, the meetings of all public boards or commissions must be open to the public. We're in a public building today. This is owned by public money invested in this facility to have public meetings. There are folks in the audience. They have a right of access to come to this meeting specifically. They have a right to be here. They may not have a right to vote or to debate all of the topics, as in public decisions that are being made, but they have a right to be in a public building to listen to what you do and how you do it. Under the statute, therefore, meetings of public boards or commissions must be open to the public. The second part of which is, how would they know to be here? Did you call them? Did you pick up the phone and call Mr. Duquesne and say, by the way, Monday night, be at the meeting? No, it's posted, it's advertised, it's available on the website. So John Q. Public knows specifically when the meeting will be conducted. So the issue is open to the public and notice to the public specifically. And the third component of which is, Joanne's sitting back there, she's not sleeping, she's not playing with her iPhone or communicating with her family, she's taking the minutes. She's keeping the minutes, which quite frankly is an important facet of how we do our business. because the record evidence of the meeting are in two different formats, one of which is the tape of the meeting, the actual recording of the meeting, but also the actual written minutes, which becomes a part of the record of this organization. So the three component parts are, they must be open to the public is sitting out there having a right to be heard. Number two, they must be notified that there is in fact a meeting, it's called procedural due process. And the third aspect of which is there must be minutes taken, so there must be some record evidence that you actually had a meeting. Now, if you're in litigation, there are some exceptions. What is the real purpose of the Sunshine Law? What is the facts and evidence that we talk about? Florida, by the way, has the most liberally construed Sunshine Law in the country. Sunshine Law, Sunshine State, it's very liberally construed. What does that mean? That the rights of the people sitting over here prevail. The rights of the public to know what you're doing and how you're doing it prevails. And conceptually, it's an important aspect of what it is that we do in public bodies. So whether you are a special district, such as Boca Park District, or you're a city government, or a county government, or a school board, under the law, the purpose of the Sunshine Law is to ensure that decisions, and we'll talk about decisions in a minute, by public bodies such as yourselves are made in open form, accessible to members of the public. There's a statute also which modified 286 a couple of years ago that says before you make a final decision, as a final decision maker, the public has a right to be heard at this podium. So for example, if you have a consent agenda, which some government agencies do, if there's a final decision to be made in that consent agenda, the public would have a right to raise their hand and be accessible to the podium to address the decision before you make a final decision under the new statute, which is modified. Decisions are official action which may include the following situations: recommendations, discussions, and deliberations. Now, you make these decisions, you just made a bunch of them, and I clarified because I was unsure myself. Commissioner Ernst raised the issue about, well, what about this item? We do these all by motion, how are we going to do that? I sought to clarify for the record that he really intended to ask for a motion to approve that particular item. So in essence, what he did was, it was a recommendation from staff, you had your conversation, you deliberated, and then a motion to actually approve it. So there's actually some action on the record that describes what occurred specifically. Who is subject to the Sunshine Law? Well, you are. You are, county government is, school boards, municipal government, and any other special districts such as yourselves. They're all part of the Sunshine Law. It applies equally to both people who are elected or appointed, because as you know, you are all elected. But there are some public officials sit in district capacities, special districts, for example, taxing districts, they're all appointed. Broward Health, for example, were 7 members appointed by the governor. All of them appointed by the governor. We have special districts in Broward County, for example, the Hillsborough Inlet District's been there since 1957, round numbers. Basically, their job is to keep the inlet free and clear for access by boating interests, as well as the jetty, etc. They're all appointed by their local governments. So the 6 cities affected by the district are appointed by their city commissions, and the county commission appoints one. But the end result is that any board or committee, so essentially there are very few limited situations when it would not be a public meeting with a public body. Elected or appointed, and also advisory boards. Now, you don't have any advisory boards, but local government does. Planning and zoning board, civil service board, art and cultural board, you name it, diversity board, call it what you will. But advisory boards that make recommendations to public bodies are also proscribed by the Sunshine Law. They're governed by the same rules and regulations, specifically. Okay, who is not? Well, the legislature essentially decided to exempt itself from the Sunshine Law. The legislature is essentially exempt. Why, you ask? Well, there are some good reasons and there's some not so good reasons. The good reasons is that the legislature is a huge organization. They would get no work done because their discussions in committees, the discussion of other moments of time would not have the access to making decisions. So they actually decided back in the day to exempt themselves from that process. And in some aspects of the judiciary can be closed as well. Certain types and kinds of proceedings are not public proceedings, and certain domestic and family matters, for example. Fact-finding committees, that's one of the exceptions to the Sunshine Law. Fact-finding basically means, let's say, for example, I remember back in the day, Coral Springs is a good example. They appointed some kind of environmental committee. And the purpose of the environmental committee was not to make recommendations to the commission in Coral Springs, but was to, in fact, gather facts and circumstances. Under Florida law, if the entity, which is the recommending body, is only fact-finding, providing facts and circumstances to a public body, then the fact-finding function strictly would not subject that board to a sunshine issue. You don't qualify within that discussion because you are the body itself. And a body such as yourselves can't be the fact finder and the decider. You with me? So the end result is that if you had in this organization a fact-finding organization to make decisions about the vernacular, for example, like the limbo or some other facts about information that you didn't otherwise have a chance to go out and get, the end result is that that would be an okay organization to not be sunshine driven. But you don't have such an organization and you are the fact finder and the decision maker. If you're both, you therefore can't be exempted from that provision. In private organizations, typically not, unless that private organization has some public role, which we can talk about later, but the end result of which they're not typically prescribed by the same rules. Okay. Here's where we get into trouble. Okay? When the Sunshine Law was first adopted back in the late 60s, early 70s, email and computers and social media didn't exist. And quite frankly, and Jake will jump in where he needs to because we have this discussion frequently when we lecture together, social media and other situations are not, they're far ahead of the Sunshine Law in many different ways. I remember receiving the first Attorney General's opinion on Facebook, for example, for Coral Springs 10 years ago. It was the first occasion to actually have the AG weigh in on whether or not Facebook, for example, was a sunshine-driven issue, which it is, by the way. The key factor is that email is the bane of our existence. It is a source of communication, not just between each of you and the public who you represent, but each of you along with staff and each of you with members of the public who come before you. It is not a tool by which you can communicate with each other. So oftentimes you'll see Jake and I, or members of our law firm, in answering global emails, bullet emails to everybody, is do not reply to all. We recommend against replying to all because when you reply to all, you begin a conversation that you didn't intend to begin. And as you slowly begin to evolve in your exchanges, you open a door of discussion which could predate the discussion that you're going to have on the dais, where foreseeable action may actually occur specifically. So one-way communication is okay, which is basically you sending out an email to the public or to others that are affected by your decision-making. But when you begin to have exchanges amongst yourselves, that is something which we suggest to you is not a lawful issue for which you need to be very careful, very thoughtful. It can be a violation, and we again don't use the reply to all mode, which I think puts you in jeopardy to some extent. We'll talk more about that with questions as well. What's a conduit? Well, that's really what it is. Third parties who are not members of a board may not be used to exchange information. So, for example, if you have an issue that you're going to discuss at the next meeting about the golf course, for example, and you know that Mr. Duquette is a source, comes to all the meetings, physically comes here and makes a presentation, very thoughtful about what he wants to do and have that conversation. If he, as a third-party intermediary, if you called him and said, by the way, I'd like to know how, let's call it, Commissioner Angle wants to know how Commissioner Ernst is going to vote on the topic, and he wants to go through the third party, and he calls Mr. Duquette and says, what do you think about Craig's vote tomorrow night? What's that going to be? What's his thinking? Or can I influence his decision through you as a source? The answer is that can't do that. You can't use third-party sources as intermediaries between each other when you are making your decisions. So you can't use them for that purpose. You can't use your lawyers for that purpose either, or your executive director. So your director cannot be used as a third-party intermediary to get you to a decision-making option. And that was one of the arguments, as I recall, Jake, in the private health matter, was that the lawyer was a conduit through which, allegedly in a conspiratorial fashion, actually violated the Sunshine Law by having what's called rapid-fire meetings. Rapid-fire meetings are where you have sequential meetings with your public body to basically evolve an answer from each of the membership till you get to an answer that you're looking to get to before the public meeting actually happens, when John Q. Public doesn't get to hear about it, but they only get to hear the decision. And that's a problem. So be mindful of the intermediaries or third parties, which are called filters or intermediaries, basically. Exceptions. There are several, but there are not that many in Florida law. If we're in litigation, God forbid, and your lawyers need your advice with regard to a pending matter for settlement or discussion purposes, there's a way to actually call a public meeting and then call for a shade meeting. You've heard, this is a sunshine meeting, there are what's called shade meetings. A shade meeting essentially is a situation where you would recess the public meeting with your lawyer and executive director to discuss the litigation matter. You would basically close the door, and a court reporter would be in the room with you transcribing your discussion. There's nothing off the record. So although the tape machine isn't going, recording the meeting, a court reporter is present during a closed-door session, referenced as a shade meeting, at which your discussions are protected. And that transcript is sealed after that discussion and is not open or publicly available until a court of higher jurisdiction either decides the case through litigation or you settle the case. So for example, in a closed-door shade meeting, you need to be very careful what you say and how you say it, because at the end of the day, that transcript becomes public record at some future moment. So I must confess to you that I've been through meetings in my experience where some public officials have said some things that they regret because they're either personal or they're derogatory or they're inappropriate, and they're set on the record, but they're also sealed in that transcript. And we've had requests in recent days for third parties to actually ask for transcripts periodically from closed-door sessions. So the first exception essentially is the attorney-client meeting for discussing pending litigation and settlement negotiations. The transcript is not public until a court of highest jurisdiction decides the matter or you settle the case specifically. Okay? That's one exception, and there are only a handful, and they're very limited. Executive sessions. We don't have that problem here. We don't have any labor organizations in this organization. If a local government, such as a county or a city, has a labor union that they're negotiating with, whether it be the FPE, the Federation of Public Employees, or the fire union, or the police union, for those who may have some recollection of how that works, collective bargaining relationships allow the local government, whether it be a special district or otherwise, if you have public employees that are unionized, to actually meet in what's called an executive session. So you have this meeting, which is a sunshine meeting. You have a closed-door session referenced as a shade meeting, and you have an executive session for labor only. And in that situation, what's interesting is it may be a posted meeting, but there are no minutes kept. There are no limitations as to who can attend the meeting, except it includes the bargaining parties from the city. And there's no record kept, and there's no record evidence of the meeting. There are no minutes, and there are no records that leave the room. Because if you take the record from the room during executive session, it becomes what? It becomes a public record. So in that limited circumstance, again, executive sessions, which we don't have here, but they do have them in other government agencies, it's a closed-door session that exempts all the documents and materials. There's also what's called procurement and selection committees and evaluation committees. We don't have that issue here per se, but some local governments do, where you essentially have a committee appointed by the organization to review proposals for RFPs, bids, etc., which may also be exempt from time to time. And there's one last exemption which came in after 9/11, the security of public buildings. Jake and I like to refer to it as where's the switch to the water plant, so you know where it is. You don't want to become a terrorist with the switches. And in local governments, they have that switch, or whether it be security of this building, for example. If you wanted to have a meeting under that statute, which is 281-301, because you wanted to make sure that your properties were protected and that there were security measures to protect them, we could have a closed-door meeting to talk about that issue alone. Cameras, other security measures, and other things that might be implemented, so that the public is protected by your private session, and that those who would choose to violate their rights do not know exactly how you configure that. So certain building plans, for example, are not public records if they show where the switch is to the water plant, for example. Again, those are the only limitations under Florida law which allow for not meeting in public in the public light. Violations. Well, the Broward Health folks were charged not just with the civil end of the conversation, but they were charged with the criminal side, the criminal end of the violation, which basically says any member may essentially be charged with a non-criminal infraction up to $500 in fine, or you may be also charged with a sunshine violation, which is criminal in nature. They were charged with misdemeanors. I think they're secondary misdemeanors, which has jail time affixed to them. It's a serious thing. It's not a trifling issue, as a matter of fact. So violation of the sunshine law can subject you not just to civil penalties, but also to criminal applications as well. And it is our job as your lawyers And it's your jobs as public officials to be vigilant about that, and to be conscious about the fact that wherever you go and however you operate, whatever you may do, someone's looking over your shoulder. I don't mean to make you paranoid, by the way. But, for example, I had the pleasure, so to speak, back in the day, I was the city attorney for Coral Springs for many, many years, almost 20, for example. And there were 2 public officials there who were charged with sunshine violations. Unfortunately, I was the only staff member who was subpoenaed by the state attorney's office to testify in their trial. You know, I was not there at the event, as it were, where the alleged violation occurred. I was actually subpoenaed to talk about the process of how government works, how local government, civics works in the context of the charter and the code of ordinances. But the very subpoena to me put me at risk with the public officials who thought that I was going to testify against them. That case was dismissed, by the way, because the first and only question the defense lawyer asked me in court was, Mr. Gorin, where were you on the night of XYZ when this discussion allegedly occurred? Were you there? The answer was no. No more questions. Because I didn't hear it. I didn't hear it. I didn't perceive it. I couldn't touch it. I wasn't part of it. And that judge did dismiss the charges against the 2 folks there, and the governor reinstated them both from their suspension. However, the key is that there are criminal penalties. It's a serious issue. More and more in recent days, charges occurred. These are aside from other charges such as Chapter 838 violations, which are also in state statute, bribery, conspiracy, unlawful compensation, and the criminal violation of the misconduct of public officials, which, by the way, just occurred in Broward this past week. The former mayor of Hallandale Beach, Joe Cooper, was acquitted on 6 counts. Bribery, conspiracy, unlawful compensation, and the criminal aspect of misconduct. All 6 counts. She could have been in prison for 20 years for those violations, and was found not guilty by the jury. We could spend much more time than you have this evening to talk about sunshine, and I want you to hear about public records in a moment. But we caution you, and I'm going to broach a topic that I'm going to ask you to listen carefully if you can about this. You each have the independent legal right to look at the district's server, which has all the emails on them that you otherwise create periodically. It is not unlawful for any one of you to look at those records. It's not unlawful for you to have the public look at those records. So we many times get public record requests that relate mostly to emails. Because emails, again, the bane of our existence, they're also the principal source of communication. I caution you, however, that in the context of what you review and how you review it, that the Sunshine Law basically says that 2 or more members of the same public body cannot discuss and review a matter that has yet to come before that body, before the public has a right of access to know about it, which is the minutes or kept, notices of the meeting, and the public has a right of access. When any 2 or more of you, 2 or more of the same public body begin to formulate a decision about something before the board actually gets to decide that issue, it's a potential violation of Sunshine Law on the criminal or the civil side. So inasmuch as you may choose to look at each other's emails or record evidence of things, it's not a problem to do that per se. It becomes a problem when that information is used to generate discussions between 2 or more of you outside the right of the public sitting in this room to know what you're doing and how you're doing it. It's a sobering comment I make to you only because of the fact that we're aware of it, and I'm aware of it because I've had the conversation with many of you about how the system works. And it's not irreverent. It's not uncommon, for example, for elected officials and appointed officials to ask for records, and that includes email records. But I suggest to you that using conduits, which is third parties to communicate your decision-making to another or to persuade another to get information for you, city manager, executive director, lawyer, member of the public, etc. We just want to give you a broad overview of the Sunshine Law and how it works. There's some tabs in this book for a reason. Having been to the grand jury now twice in 2019, Jake was actually with me during one of my presentations. He came there as my lawyer, as a matter of fact, which was an interesting event. And the second time I went back, they wanted to ask me some more questions. The grand jurors, and there were 21 of them, I think, though? 21. Ever been to a grand jury, by the way, anybody in the room? I was at a grand jury once before in Broward County when the Broward County Expressway Authority that built the Sawgrass Expressway there were some indictments that occurred there as well. I can tell that story. And I was once in a grand jury on the West Coast in, I forget which county it was. I was an investigator, lawyer for an election matter, and then went to a grand jury. Grand jurors are pretty interesting folks. They look just like you. They look just like you. They look like everybody in this room. They're just normal people that were subpoenaed to go to a grand jury instead of going to a trial jury, which is either 6 members or 12 members. And they sat for a period of months, and they, in Broward, they have a nice brand new courthouse, and I went into the grand jury room, and everyone has a nice desk, everyone has a very nice computer, and they all had these books. They also, by the way, I didn't know this until I found out, that I made a presentation like this some years ago, a couple of years ago, for the Regional Planning Council for South Florida. That was on YouTube. Somebody actually taped it. And they showed, if you Google my name, you'll find it online. They actually showed that as a premise to the grand jurors. So not only were they paying attention, but they'd done their homework. And what had happened was, from my first testimony and multiple witnesses thereafter, I was called back to answer questions. And I could tell by the questions they asked me that they had begun to develop their own recommendations based on what they'd heard, not just from people like myself, but from others as well. And it was through the studying this book, listening to the testimony of others, and making some very independent decisions. So I make the comment, not as a sobering comment, but as a recognition that we live in a very sunshine public records world. You're going to hear some things in a minute from Jake, which will be eye-opening for you as well. I know time is short. I'm grateful for your service on this board. I recognize the fact that we serve at your will and pleasure, and it's an honor and privilege for us to be your lawyers. It's also an honor and privilege to represent the people sitting in the audience who you responded, who are your constituents. And we make every effort to protect you, not just what happens during the meeting, but also what happens outside the meeting, what happens in between meetings. Because as public officials, you file your Form 1, right? Yes, say yes, please. We file Form 1s. We as local government attorneys file forms as city attorneys, for example. I've been filing one for many, many years. And we, in the statute, in Chapter 112, which could be a whole separate discussion we should have at some future moment, we're referred to as local government lawyers. We are under the same rules that you are. I actually was around when that rule, when that statute was actually adopted some number of years ago. But being prescribed by the law, being affected by the law, being impacted by the law matters. And you are all impacted by the law. One of the things that, and I'll close with this, and I would hope that you've at least gotten some thoughts out of this discussion, is the fact that we do care about how you react to things among yourselves, with the public, and with third parties. And one closing item. In the Coral Springs situation, apparently there was an investigator from the state attorney's office that happened to be in the same location as the two officials that were charged with sunshine violations. You wouldn't know that because they look just like you and me. But they were in the same bar, the same restaurant, and they overheard allegedly overheard the conversation. So you never know who's really listening. Again, paranoia is an interesting psychological concept. I really don't know how to describe it except to suggest to you that I'm not asking you to look over your shoulder or look in the rearview mirror of your car, but be mindful of the fact that as public officials, as Jake and I used to say, used to be under a microscope. You're now under a floodlight. You're under a floodlight. And as I recall, although I think that the meetings were reasonably civil in the context of the last 6 months of meetings on the golf course, the room was full of people. And they were there because they had interest in what you were going to decide, how you're going to decide it, what you're going to do. And some people weren't happy with those decisions. They're not as happy as they would like to have been, or as happy as you might have been, as the case would be as well. So the third parties are the public. And when this manual got published, when the Constitution was amended to provide for the Constitution Amendment providing for sunshine and public records, it had the public at heart, principally. To the extent that we can, let me let Jake segue to his presentation. We can answer any questions you may have. We appreciate this opportunity. We have a lot more to say, but the time is short, and we appreciate you listening at least to this general concept of approach that I think will help you be better public officials. And we thank you for that. Thank you very much. Jake?
Okay, thank you. And I know that time is indeed short, and Sam and I try to keep this to about 20 minutes, which is not always the easiest thing to do, but we'll do our best. And as Sam said, every year, the Attorney General's office puts on a 2-day presentation, 8 hours a day on these 2 topics alone. So over the course of the past 15 minutes, the next 15 minutes, we're really just going to scratch the surface. But as Sam spoke briefly about the Sunshine Law, I'm going to talk a little bit about public records. And those two both fall under the Sunshine Amendment, which Sam referenced, and are both occasionally confused and intertwined as considered the Sunshine Law, but legally they're different. And Chapter 286 is very brief, as Sam said, it's about 4 or 5 pages. Chapter 119 is a lot longer. That's the Public Records Act, and quite a few of those pages deal with exemptions that we're going to talk about very briefly. But one thing to keep in mind is that Chapter 119, much like the Sunshine Law, is very liberally construed in the favor of open government. And when in doubt, unless a particular record falls clearly within one of those exceptions under the law, we're all talking about public records. So first, definitions. Chapter 119 tells us that public records means all. And that's really the key. All means all. When we're talking about public records, we're talking about the content. The format really is irrelevant. Any document, paper, letter, map book, record that's made or received pursuant to law or ordinance, or in connection with the transaction of the official business of any agency. That last sentence really is the essence of what we're talking about when we're talking about public records. Whether the document, whether the record was made or received pursuant to law, or in connection with the transaction of the official business of this agency. That applies to emails, that applies to letters, correspondence. It also applies to social media. And I know Sam briefly mentioned social media earlier. I'm going to digress in a few minutes and talk a little bit about some of the impacts that we've seen in a relatively recent vintage as it relates to how social media has affected both public agencies and public officials, how they try to navigate their own use of social media along with the public records law and the Sunshine Law. So Sam spoke about computer records and email. The same is also true for public records. In the case law, again, going back to 1982, tells us that information stored on an agency's computer is as much a public record as a written page in a book or any tabulation stored in a file. I mean, we know, just as a matter of law, electronic communications are public records because, again, it's all dependent on the content, not so much the format. Same is true for email. But one thing to be mindful of, in 2003, there was a very important case out of Clearwater that's worth mentioning. You all have Boca Park District emails. When you send emails from your Boca Park District email address, those emails cross over the district server, and they're preserved as a matter of public record by the district. If you engage in public business on a private email address, those emails are still public records. So in other words, using a private email doesn't negate any requirement to retain information that might otherwise be considered a public record. So if you are the custodian of those records, if you use private emails to conduct public business, you're the only person with access to those emails, and you are the records custodian under Florida law. And you have an obligation to retain those records or to forward them to your executive director or your board clerk, secretary, to ensure that they're preserved. Our best recommendation, our best advice is if and when you conduct public business by email, use your public email addresses. If people send you emails at your private email addresses relative to this agency, to your public business, respond to them from your public email address, or copy your public email address on your response, just to ensure that those correspondence get captured by the district server. It'll take the burden off of you of having to retain each of those records. So the Florida Department of the Library and Archive Services, the Division of the Department of State, they have a number of retention schedules. I think there's about a dozen of them. There's one for hospitals, public hospitals, there's one for law enforcement agencies, there's one for public universities. There's also one for local government, applies to municipalities and counties. There's a separate one for the school board. But in those retention schedules, they include an index in the back that lists about 100 or 120 different types of records. And there's a presumption that every record that's created by an agency would fall within one of those specific categories. And each of those categories has a different retention period. They go from transitory messages, which are the records that require the least amount of retention, to records such as ordinances and resolutions and minutes, which need to be retained in perpetuity. The transitory messages I highlighted and want to talk about just briefly, because we've seen this issue come up quite a bit in recent years as it relates to text messages. And very early on, over the past 4 or 5 years, when texts were becoming a more prevalent method of communication, a lot of public officials that we encountered were essentially writing off all text messages as transitory in nature. It was just a text message. But again, keep in mind that the retention period of a public record depends on the content, again, not the format. So a text message can be transitory. What a transitory message is, it's a message of short-term value, again, based upon the content, not the format used to transmit. But transitory messages are not intended to formalize or perpetuate knowledge, set policy, confirm transactions, or act as receipts. So typically when we get phone messages or calendar confirmations, that's what we usually think about as being a transitory message. So that could be an email, that could be a text message, but they only need to be retained until they've lost their administrative value. So once you return that phone call, once that appointment is come and gone, though still public, there's no longer an obligation to retain those public records. But again, text messages, and I think I have a slide coming up in a second we'll talk about, text messages have been a real challenge as it relates to the preservation of public records, and there have been some case studies and some occurrences throughout the state in South Florida and Orlando in particular, where text messages have really become a challenge. But so who's authorized to inspect public records? Well, there's an easy answer. The answer is anyone, for any reason. There's no requirement that a person have a legitimate purpose or a special purpose. There's no requirement that public records requests be made in writing. They can be made orally. They can be made anonymously. Our staff serves as our collective records custodian. I know Brianne identifies as the records custodian in all contracts. There was a change to Chapter 119 about 4 or 5 years ago that requires every contract for services includes specific language in those agreements that ensure a preservation of public records by third parties, that ensure those records are turned over to the public agency at the conclusion of those agreements, and that also identify the records custodian. It specifically requires that that custodian be identified in 14-point bold font, bigger than any other text on the page, so that our vendors know if and when they get public records requests, who they're supposed to contact to help facilitate those responses. But the staff, as our records custodian, has the obligation to respond to all those requests that do come in. And again, the custodian is the person elected or appointed by the state agency, county, and municipal officer charged with the responsibility of maintaining those records. Typically that's the staff, but the exception is if you have an email, if you have a text message, and you're the only person that has that record, aside from the person you may be corresponding with, if you're the only public official that has those records, you're the custodian of those records, and you have an obligation to retain them. And that's true for social media as well, which I'm going to talk briefly about in a minute. So when must an agency respond? Well, we know that we have to acknowledge the request once it comes in. We have to let the person who's made the request know that it's been received and it's being responded to. But state law doesn't tell us how long we need to, or set a time frame by which we need to reply with that request. The answer is we need to reply within a reasonable amount of time. And that could mean different things for different requests. I'm aware of at least one request we worked on some number of years ago that took several months to respond to. And under the circumstances, it was perfectly appropriate and reasonable for it to take that long. Depending on the nature of the request, we can ask the requester to put down a deposit. We can ask for upfront payment in certain circumstances. If a person makes a public records request and refuses to pay for it, we're not obligated to respond to subsequent requests by that requester. So there's some case law that does help us in dealing with some habitual public requesters, and there are a couple of different individuals and organizations in a recent time in Florida that were making fairly repetitive and egregious public records requests to public agencies. They were trying to get public agencies in a kind of a gotcha situation, failing and I guess violating some of the more technical provisions of Chapter 119 that resulted in some lawsuits in recent time. But ultimately, there's no statutory time by which we're required to respond other than to communicate with the requester, just to ensure that they're aware that we are in fact responding and working on those requests. So exemptions. Chapter 119 is very brief as it relates to the substance of the law, but the exemptions are quite long. We know that they're liberally construed in favor of open government. The exemptions are very narrowly construed. And if we cite or assert an exemption, then the burden is on us to identify what that exemption is. We can't simply respond to a request by saying this is exempt. We need to identify what the exemption is and cite to it in our response to the person making that request. Bree, did you have the other, was there a separate slide of social media? No? I had a couple slides that we had stuck in there that I do want to talk just briefly about as it relates to social media, and that's okay, I don't need the slides more. So Sam talked a little bit about the Sunshine Law, and I spoke a little bit about public records, but I wanted to talk just briefly about how both of those things collide on social media. Sam mentioned the AGO that our office got for the city of Coral Springs related to Facebook back in 2009. And what that opinion said was that clearly the Sunshine Law and clearly the Public Records Law applies to social media. In fact, there's some case law going back in the late 70s that says no evasive means or methodologies may be used to avoid both the Sunshine Law and the Public Records Law. But so while public officials can utilize social media both through the agency and individually, because the Sunshine Law applies, what that means is you can't have a dialogue on a blog or on a Facebook page among members of the collegial body. So our chair and vice chair couldn't engage in a dialogue on a social media page about something that may come before this district. That would be considered a meeting for purposes of the Sunshine Law. I know that the district is in the process of considering or looking to develop a Facebook page of its own. I would trust that many, if not all of you, have your own Facebook pages. When you engage in public business on a Facebook page, and I use Facebook, but it would apply to YouTube or Nextdoor or any of the social media, Instagram, whatever social media platform you may be using. I'll just use, again, Facebook for the general. If you're engaging in public business on any one of those platforms, that information is a public record, and the burden is on you to retain that information. We had, and there was a slide in my last presentation, that was a public records request that we received for the city of Pembroke Pines back in 2013, I believe it was, and I'll read it to you, it's not very long. What the request said, here, Pembroke Pines, December 18th, 2013, Madam Clerk. For the last 3 years, or whatever the maximum records retention policy permits, I'd like to obtain copies of all comments made by a particular commissioner on every single blog, newspaper, or digital domain. Kindly acknowledge receipt of this request. P.S. Your city attorney is a moron, kindly indicate that to him. That would be Sam. The person who made the request was a notorious blogger in town, and the commissioner whose information that he sought to receive is one of the, if not the most prolific user of social media that I'm aware of. Not only his own social media, but if there are some, this is in Broward, in South Broward, there's some local political blogs where he will comment ad nauseum about whatever the topic of the day is, and he will comment, identify himself, Commissioner so-and-so, and this is what he has to think about this information. These are not city pages, these are not his pages, this could be the comment section of the Sun Sentinel article, which he's prone to do as well, and he'll verbalize whatever he has to say about that particular issue, some of which relates to city business, some of which doesn't. But this request wanted all of that information. All comments made by this commissioner on every single blog, newspaper, or digital domain. And again, this is going back 6 years. At the time, there's been some evolution in the law here, but at the time, we took the position that the information is either not a public record, and if it's not a public record, then the city, if it isn't a public record, the city's not the custodian. If he wants the comment sections from the Sun Sentinel's website, he can go to the Sun Sentinel and get that information. There's a popular blog in Broward called Broward Beat. If he wants the information from the Broward Beat website, he can go to the Broward Beat website and get it. We took the position it was not a public record, and if it is, the city's not the custodian. And after this particular requester screamed up and down that we were all going to hell and threatened to sue the city, and that issue ultimately fizzled. But the substance of the issue is unresolved. I'm comfortable then, and I am now with our answer at the time, but undoubtedly that issue will continue to play out as the use of blogs and social media continues to proliferate. There were also a couple cases earlier this year which are not specific to public records and Sunshine Law, but I just wanted to mention as it relates to social media. Everybody aware of the lawsuit that was started, I want to say last January, regarding the president's Twitter account and the president's intent and effort to block people from accessing his Twitter account. There was an organization called the Knights of the First Amendment Institute at Columbia University. They filed a lawsuit in federal court in New York where they sued the president to prevent him from blocking people from accessing his Twitter account. And they won. And his position was it's a private account that he posts both public and private business on. That argument didn't fly with the courts. And there was some language that the press secretary at the time had used, suggesting that when the president uses his Twitter, that he's making an official statement of the White House. And the court relied on some of those representations to suggest that as a matter of law, the president couldn't block somebody from accessing their Twitter account when it's used for a public purpose. In January of this year, the appellate courts, I believe it was the Fourth Circuit in Maryland and Virginia, rendered a decision which is also worth noting. There was a situation where the chair of the Loudoun County Board of Supervisors, she used a Facebook account for a variety of different means, and at one point a constituent posted some information on her Facebook account which raised some allegations of corruption by some members of the school board in their area. And she didn't know whether the allegations were true or not. She just didn't like the tone of those comments. So she deleted the records or the post from her Facebook page, and she blocked that user from accessing her account. A couple days later, she unblocked the user, but that wasn't enough to stop him from suing both her and the county for violating the First Amendment and for taking action that violated the color of state law, which was the language that was used in the lawsuit. The court went through a very detailed analysis, specifically on the issue of blocking people, public officials blocking people from Facebook accounts. And I don't know how you all utilize Facebook or social media in furtherance of your public business, but there are a couple words, comments in that opinion I wanted to read, because the court used this term, a tool of governance. And it was determined that this particular county administrator, county supervisor, used her Facebook page to further her duties as a public officer, and that the page was used as a tool of governance. And there were 8 things that the court identified that she specifically did on her Facebook page, which was kind of commingled with recipes for turkey and salad dressing and other things she was doing, but because her page identified herself as used her official title to identify herself, because the page was categorized as that of a government official, the page listed her contact information, including her county email address and her county telephone number. The page included the county's official website address. Many, if not all, the posts were expressly addressed to her constituents. She submitted posts on behalf of the Board of Supervisors as a whole. She encouraged her page as a channel for dialogue among her constituents, and that content posted on the page had a strong tendency towards matters related to her public office. Now again, she did all kinds of private things on her Facebook page as well, but the court identified these 8 characteristics that were met on the page to suggest that it was in fact a public page, even though she asserted that it wasn't. But because she used that page as a tool of governance, it suggested that it was a public forum. They got into the issue of a public forum versus a limited public forum and some First Amendment analysis. But ultimately, the way she used her page precluded her from blocking members of the public, constituents or otherwise, from accessing that information. So again, not knowing how any one of you uses your social media accounts, just to be mindful that there's some very recent case law out there which provides some legal guidance as to the manner in which these accounts should be used. Like I said, I know I really just scratched the surface on public records. Sam touched on the Sunshine Law. I know the hour's getting late. We don't want to keep you here too late, so we're happy to answer any questions if we can. I know this is long overdue, so thank you for your patience and attention. Appreciate it.
Thank you, Sam and Jacob. Very, very good. Thank you. Commissioner, did you have any questions for Sam and Jacob?
Yeah.
Steve?
Yeah. First question I had was, as far as minutes go,
Yes.
If there's an audio recording, is there a requirement that exact written minutes be taken?
The law requires that there be minutes kept of the meeting, although the tape or the evidence of the meeting is best reflected by the tape itself. The law does talk about minutes. We believe the written minutes are required. They don't have to be verbatim minutes,
No.
but they must in fact be summary minutes. They must have some reflection. because John Q. Public may not have access to a computer or a device that can actually, or he or she may be hearing impaired, for example. So there must be some reference and access point to written minutes.
Yeah, and also on to follow up on that, while we are required to have minutes, you're not required to audio or videotape your meetings yet. Now, that may change at some future moment, but if you do make an audio or a videotape, that then becomes public record you're required to retain.
Okay. And the other question I had, we were talking about, when you were talking about executive session,
Yes,
and you talked about procurement and selection.
correct.
We engage in that at least 2 or 3 times a year on RFPs. Can we do that legally in executive session, or must we do that in open session?
You don't, we can have this discussion. You are your own selection evaluation committee. If you would have appointed one, if you had an organization which would facilitate doing so, then that group would actually make a recommendation to you to make a recommendation on a procurement of some kind. Their interviews of the proposers would be privileged. But because you don't have a committee that's doing that work for you, you are the committee. The end result of which I suspect that those are not privileged per se.
They're not. No, there was a change to 286, I want to say it was in 2013, round numbers, about 6 or 7 years ago, which suggested that the interview portion of a procurement process could be exempt. And at the time, it gave agencies discretion to exempt those meetings. Now, nothing was off the record, because much like a shade session, where you have a court reporter, all of those interview or presentation sessions were required to be recorded, required to be preserved, but there was an anti-competitive feel in the legislature in 2012, 2013, where if you were hearing presentations of potential vendors in a public meeting, the person who presents second or third or fourth may be given an advantage over the person who presents first, having heard some of the questions and having heard the way some of those exchanges might have gone. So there is a mechanism that allows for the presentations, just that limited portion of those meetings, to take place in a closed door setting.
So if, for example, we're doing an RFP
Yes,
on a second field house,
correct.
if the board as a whole designated,
Itself is the committee.
or designated itself as the
Or-
committee,
or a subcommittee.
or a subcommittee,
Yes.
would that come under the aegis of an executive session?
If that committee or subcommittee is making a recommendation, then the interviews can be privileged. But the recommendation would be public. So the deliberation of the committee would be public,
Right.
but not the interviews. They're retained publicly as public records, but they're not public.
So in other words, the committee, the subcommittee,
Subcommittee appointed by the committee of the whole.
by the
yes.
committee, could interview each contractor, say, separately,
Yes,
in executive session, and then come back to the board as a whole and say, okay, we recommend that John Smith be the vendor used, or Jacob Jones, et cetera, et
the
cetera.
subcommittee's recommendation and the way that they got to the recommendation would be a public meeting. They would say, we've interviewed 13 people, we narrowed it down to 10, we narrowed it down to 5, we narrowed it down to 3, and based upon the 3 we analyzed and measured them, we recommend the ABC company.
Gotcha.
And at that point, that's the recommendation to the full board. Because we're a small organization, this doesn't lend itself to that kind of process, but is it theoretically possible? Absolutely. Could be done.
Okay.
Could be done. Because back in the day, as Jake mentioned, there were situations where local bodies like yourself would tell, let's say the 3 proposers, would tell the 2 of them that weren't interviewed to step outside the room. Well, you can't do that, because the public has a right to be there, and they're members of the public. So the legislature responded to that in the fashion which counted, provided some additional protection, specifically.
Okay. Thank you.
Good idea. Thank you. Happy.
If a commissioner asks the executive director to find out what other commissioners are thinking, but does not get back to any other commissioner, but she keeps that knowledge, is that a violation?
Let me answer the question by turning it to myself or to Jacob as your lawyers. There are moments of time when I, even in this organization, have known what each of you are thinking without the benefit of telling any other member of the board what you all are thinking. And the obligation I have as your lawyer, aside from being the attorney for the board, is I have an ethical obligation to maintain the privacy of the conversation as much as humanly and legally possible. But what I talk about with any one of you, what we talk about with you, we don't share with each other, we don't share with any other member of the board. The same rules would apply to the director. We talk about the conduit theory. Brianne or Jake or myself or Melissa or Joanne, they can't be conduits between members of the board. They also cannot be facilitators, because in the cases in which there were these rapid fire meetings that I discussed earlier, in that case it was a school board meeting or school board situation where the school superintendent had these successive rapid fire meetings and began to develop his own plan to be able to actually frame out that plan to know exactly what the board might approve, because he talked to everybody in this rapid fire succession process. The end result is that it's privileged, and you shouldn't be discussing with any other member what you know. Now, that creates a lot of challenges. It just does. I can honestly tell you that in my career, in very few instances was I ever asked by any board member what another board member was thinking about a particular matter. I don't think that Jake has either.
No.
I've never been put upon by anybody to ask that question. I have been asked periodically is, what do you think may happen? Or what do you think, what are the tea leaves telling you about what's forthcoming in some regards? And I think that we as lawyers can suggest in a non-decisional way, but in a global way, that the subject matter has some favor in the context of being a topic that's important to everybody on the board, without getting into the specifics of what individual board member is thinking about what they may do or not do. Because at the end of any one day, when you meet in this room or anywhere else for that matter, a public building, and you make a decision, it's on the days where you make the final decision. So not any one of us sitting as your professional staff can preempt that discussion, that decision making. It would be absolutely unequivocally wrong and legally improper for we as your lawyers or for Brianne as your director to facilitate the exchange of information between any member of that board, the board, to get to a particular conclusion, either to help you to know what your colleagues are thinking or to help her to do best as to how she should make a recommendation. Unfortunately, the Sunshine Law puts you in a very unique place. If you were personal friends before you were elected, that relationship changes because we've come to learn, for example, that when people file complaints against public officials, I remember sometime years ago, we used as an example, in Lighthouse Point, it's basically a city that's surrounded by water in many respects. And they have a code enforcement director, and they have a code enforcement staff. And two commissioners were intended to go on a boat through several canals looking at the backyards of homes, just to basically review the information about that situation. Just how did people's backyards look in some respects. And they went out with the code officer together, which was not a particularly wise decision, by the way, but they did. And people took pictures of them going up and down the canals. And guess what they did? They filed a complaint with the state attorney's office, suggesting that there were sunshine violations because they were speaking about, allegedly, things that might otherwise come before the full commission regarding what they were finding during the course of their alleged fact-finding. Remember, you as public officials, as electeds, can't be fact-finders and deciders. You are both. You cannot be just fact-finders. So, end result was a real pain in the butt. They called down witnesses, people had to testify, they had to give sworn statements, etc. The appearance of that situation just didn't look good from that perspective. And we have to be conscious of that situation because it can happen and did happen in that situation. But the key factor is that there are several fair game topics. You know, baseball, the weather, and your children. Unfortunately, other topics that might otherwise occur are not fair game. And there's no such thing as a social media exemption for the Sunshine Law. And there's no exemption for having dinner with your colleagues because it's not during a public meeting. It unfortunately changes the texture of your relation, whether you love each other before or you had a relationship of some kind before. Your oath of office changed all of that. Because unfortunately, you're public officials 24/7, whether you're in Publix or CVS or sitting on this dais. And you are targets to a great degree. You're targets because people know you. They think that you're going to help them, and you can, because that's what you do. You make decisions that affect their tax-paying obligations and their parks and recreation needs. Now, what's to say, for example, when you meet somebody at Publix or CVS and you have that conversation, and that person unintentionally becomes a conduit for other members of the board, or chooses to suggest that they are. Just be thoughtful that one needs to be thoughtful at all times. Your privacy rights, unfortunately, have been affected by your oath. And whatever private life you have is going to change a bit. I know that many of you have been on the board for a long time. You've come to realize that you become a little isolated because of that. And the decisions that you make are difficult, and they're challenging, and open to public scrutiny. And the pressures of the moment from third parties such as voters and others can create some difficult times for you all. And I know that Jake and I have watched this over the past number of months with regard to the golf course project. All good faith intentions were offered to make the right decisions, and hopefully you're in that mode as we speak. But I must confess one thing to you. I must say that in most instances, I saw a lot of civility among not just all of you to each other, but also to the members of the public who came before you. They were also reasonably civil about their approach. And never in our experience as lawyers for public entities have we ever seen a situation where people came out to a meeting at the podium and actually supported tax increases. We've never seen that before. We've rarely ever even heard about that before, but in this instance it did occur. And you had to deal with it. You had to deal with it in a very thoughtful, professional, public way. I mean, you couldn't go to the back room and make a decision. You had to make it right here, on the record. No, nothing off the record. And we admire you for that.
Commissioners, do you have any other questions for our legal counsel?
I have one.
Please, Greg.
Just so I understand what's required by law, every commissioner and elected official in Florida has to watch the video, is that correct? Is that a requirement?
No.
It's not a requirement?
No. There's a statute now governs electeds. It does not yet govern appointeds in that regard. In Broward County, for example, there is a local ethics code. There's an ethics code in Palm Beach County as well. To the best of our knowledge, there's nothing that requires you to do that.
Okay.
Under Chapter 112, which is the ethics code of the state of Florida.
So there is no requirement for a 4-hour training class of sunshine?
I don't know.
There is a requirement for constitutional officers, for elected municipal officers, and for, I believe it's county commissioners.
Okay, and I sense you guys are pretty passionate about both the sunshine
We love this stuff.
and the record stuff.
We actually are.
How often are we required to go through this with you?
I would suggest at least once a year wouldn't be the worst thing in the world.
Recommended, you're recommending, but it's not required.
No, and we'd like to also suggest that Chapter 112 is something that should be added to the mix. One more thing if I can.
Okay.
We were Broward Health lawyers for a long time. They actually adopted I think the special act actually required it.
It did.
It
There's
did.
only the amendment.
Yeah, when we got there, they didn't have an ethics code. They were required by the special act to have an ethics code adopted, which we helped them to draft. We don't have that in our special act. It's not in there. It doesn't require you to have one. Could you have? Absolutely could, if you chose to. And we'd have to comply with it. But under the current circumstances, your special act, your charter does not require that specifically.
Okay, all right, thank you.
Because I know when you sign off on the Form 1, it talks about the, something about,
You check the box, have you satisfied the 4-hour training requirement?
Right, so Form 1, refresh my memory, what is that? That's the,
Statement of financial interests.
okay, that's your annual.
every July 1, correct.
Okay, yeah.
Correct. It's not a Form 6 that requires net worth statement, but this is basically where you drive your principal income from,
Right,
essentially, without mentioning dollars and cents.
so you do have to say you,
Well,
in 4-hour training class.
there's a checkbox.
Yeah, you're not required to, you're not required to satisfy that requirement under state law. Doesn't apply to special districts.
Not yet.
Yeah, that's a good point. Not
And I
yet.
say yet because it's been debated for a number of years, and it should be. But it's not yet in the state law that requires you mandatorily to sign off on that particular obligation. We don't have to do that. But local officials under certain local ethics codes are required to.
And that's a good point, because we fill out the same Form 1, and that requirement does not apply to us.
Okay, thank you.
And if you look, I'm sorry, Commissioner, one more thing. That checkbox specifically for elected municipal officers.
Okay,
It's funny, if I may quickly, when we first were hired, Craig actually asked us that question. you may not remember this, but you did, and
That's why I keep bringing it
No.
up.
I'm not suggesting.
See if I got a different answer on that. It's me all the time.
It's a good thing that you asked, because when you look at the form, it's confusing. You say, so what do I do? I don't have my 4 hours, what am I gonna do about this? The answer is that the checkbox doesn't apply to you, or to us. But I will tell you that in repeated sessions over the past 3 to 4 years, it's a topic of discussion. And the legislature likes to inflict pain on all people affected in a similar way. And you are on the hit list for that particular purpose.
It is painful.
Special districts, in particular, you should know that there's movement about to eliminate special districts, actually merge them with the local government.
Somebody said something about that at the last meeting.
There's actually been suggestions about finding a way to liquidate special districts and liquidate their assets and join them with the adjacent local governments. By some state legislators that had a bad relationship with special district and chose to open up that door of discussion for whatever reason. So,
But how long has that been going on?
3 years, yeah, 3 years.
I'm not on social media, but I know some people are. How would you even begin to gather?
Gather what?
Like, you're the custodian of your information, and if somebody requests that information.
There's not a good answer to that question. We've been asked it. We get asked it a lot around election time, when we see the volume of public record requests tend to heighten for, campaign and political purposes. Short of taking screenshots, I'm not sure I have a good answer for you. Other than,
I don't need it, but.
I can tell you that the records are public records,
Mhm.
and if you're the only one that has access to them, you're the custodian of those records. So screenshots and making sure you don't delete anything is two good approaches.
Be careful how you block people.
Or just don't be on social media.
Well, see, I tend to lose all credibility. I've got about an hour-long social media presentation, and at the end, I'm not on social media either. So when I kind of, work my way through the way some of these platforms work, I tend to lose credibility as I go. But yes, suffice to say that's correct.
I can offer you an example which may be useful. My daughter is a lawyer. She was a former felony prosecutor in Broward. She just left that office after 9.5 years. She now works for Geico as a civil practitioner, taking care of 2 little ones at home. Attorneys that work for Mike Satz are not allowed to be on social media, formally. That means that my daughter couldn't formally be on social media with her own name on social media. That's not to say, for example, and I can't know this under oath, but that there are members of that staff that are on social media, but not for the purposes of social media. They're on for the purpose of deriving information and basically trolling social media for information. The public corruption unit did that routinely. Some of the tips that they got were from the stupidity of people offering on Facebook, for example, or other social media platforms, where people just did really dumb things or admitted dumb things, like stealing a judge's plaque, for example, and putting it on social media. Having been in a courtroom and stealing the judge's plaque, and you put a picture of it on social media, well, how dumb is that? Well, the answer is that unfortunately you're under that microscope and that floodlight at the same time, and unfortunately it's the way it is. We just want you to be thoughtful about the fact that not to make paranoid, just be thoughtful about the fact that you did take that oath, and it does put you in a very unique place. Place that only a certain number of people ever get to realize. But it's not a comfortable place to be, because you can't run away from it. Because at least twice a month, you're sitting in this room with these microphones on, with the public having a right to your access at any one moment in time, or at Publix, or at CBS, or in any place you're in public. Your privacy rights are not dramatically, but they're certainly affected in some fashion. And we as lawyers get to observe that. Our rights are affected to some degree as well. But we get to observe other public officials, and it can be very annoying sometimes. And it can be very challenging sometimes. It can be very comforting and very happy, very positive sometimes. It has all the various emotions. Because making decisions for a public entity are not easy. Even approving minutes can be difficult sometimes, as simple as that may seem. So we thank you for your service. We thank you for your commitment. We also appreciate the fact that you gave us some time to do that. Because we do like this stuff. It really does matter, because at the end of the day, we want to protect you as much as we possibly can. And as there used to be an ad on TV back in the day, Fram oil filter ad, pay me now, pay me later. We would rather that you actually pick up the phone and call us. People actually use the phone still. It's still possible. Or text us to call you, or in some fashion communicate with us before a decision gets made, or before something occurs that we can help you with. as opposed to calling us a week later when it may be too late to fix the problem. The pay me now, pay me later concept actually does work. We don't derive any pleasure in your mistakes. We all make mistakes, by the way. I make mistakes, Jake makes mistakes, we all make mistakes. We take no pleasure in that, but we try to preempt the discussion by trying to help you beforehand. I suspect that many of our colleagues would prefer to have the former occur because, there's the litigation occurs and cost and expense arises. It benefits the lawyers to some degree. That's not who we are. It's not what we do. We prefer to avoid litigation and to avoid the confrontation that cost and expense litigation brings to the table. It's not what we think you would like to do either, based on our experience with this organization. So that's who we are.
Thank you.
Thank you.
Well, thank you very much. We all can use this, so we'll take it home and think about it very seriously too.
Thank you.
We have an amended invoice for Mr. Ernst. We're ready.
Okay. I make a motion for approval, Madam Chair, of $285,177.35.
Second.
Does that include the payroll?
It does.
Okay. Okay. Any discussion? All in favor of approving the invoices, please say aye. Aye. Opposed, like sign. Motion passes. Joanne? We're coming up to the reports and discussions with our executive director.
Commissioners, I spoke with Mike Boca. We did not get the ILA by Thanksgiving, as everybody knows. We should have it. We're expecting to get it by the end of next week, I was told. Our next meeting is December 16th, so that falls on December 13th. I know Commissioner Rollins won't be here, so I think that it may be best to put that on the agenda for January 6th as our only topic, other than election of officers, and then just discuss the ILA at the January 6th meeting.
Is everybody good with that?
Well, I was under the impression we would have a separate workshop on the interlocal.
We kind of came up, but I just got it.
I would be honest, I would prefer to workshop it, and have a meeting as workshop is, just to discuss that and just to deal with public comments on that topic. I feel like we really do need to have a consensus before we meet with City Council and an idea as to how we want to proceed. Too often we've been caught short because we haven't had the opportunity to discuss the issues amongst ourselves. Due to sunshine laws, due to calendar restrictions, I'd like to have that opportunity to devote time, whether it's in workshop, whether it's an hour or a half an hour or whatever time it takes, so that we're all on the same page and we do it the right way.
Do you want to look at the calendar dates now, or do we want to talk about that after we actually
What's
get
the difference between a workshop and then just a regular meeting? If we had just one agenda item, that's what
the idea was just to have it, we run into the holidays after the 16th. After our meeting on the 16th, it's the holidays, the next meeting we have is the 6th, and then we could just put it on there as a topic.
What I meant to say, Steve, whether it's a scheduled meeting one way or the other. So, I mean, if we only have one item on there that we're going to discuss, I mean, is that, to me, that accommodates your request for a workshop?
Yes and no, because...
Where does it differ?
Well, and correct me if I'm wrong, the difference is if we're discussing that, and this might sound like a little thing, but at a regular meeting, the public can get up during public requests and talk about any subject pertinent to a commission business. Now that can be the golf course, or it can be resurfacing tennis courts, or it can be, God forbid, a bug infestation somewhere. It could be just about anything. At a workshop, the focus is strictly on that single issue. And the public, while welcome to attend, has to understand that any public comments they make must pertain strictly to that issue. And I know it sounds like a minor point,
It is a minor.
but we can get caught in the weeds on a public comment.
On a public comment, it's strictly that public comment. It's not a dialogue with the public about that. So, you know, not that I'm wanting to schedule another meeting or not. To me, it just seems like on a regular business night would be able to accomplish what you're talking about without getting into the weeds and just having it for one purpose and one agenda item. And that sends a message, I think. And I don't think the public is gonna, if we make that clear to everybody in advance, I think that everything will be confined to that meeting. It's just difficult enough to try to,
Yeah, no, I
make these regular
understand.
meetings, that throwing in another one, and then in January, we're gonna have the one with the city council. And I think we could very well get this done. And then, and the possibility also at the end of it, there may be some items that may need to be addressed anyway, so.
The meetings in January are the 6th and the 21st?
Yes, and then the joint meeting is the 27th.
Right. So, I mean, I think if we put the golf course as our one agenda item, or one agenda item with, we have to
Officers.
pick officers, I think people are probably only gonna make comments on the golf course, unless they have some problem with the officers that we picked or something like that. But, I mean, the odds are everybody's gonna be commenting on the golf course anyway, so.
If we decided after that meeting, Steve, is it something maybe we could add, if you felt like you weren't satisfied after the meeting, we could add another special meeting between then and the 27th? Is that?
Yeah, that would be good. Again, I'm not trying to add on to our workload. I just want to make sure that we're as prepared as possible as a board for the joint meeting. And one of the problems that we've had in the past is that as a board, we have not been as prepared. As individuals, yeah, but as a board, we have not had a consensus as to how we want to approach it.
It's just gonna depend on when we get the letter.
Yeah,
We don't know when that's gonna be.
that's true.
And so if we get it before the end of the year, then we should be able to rationally discuss this at our first January meeting.
Or at least discuss it, maybe not rational.
Well, we've always,
No,
we've been
we're
very rational, we don't always agree, but we've been very rational about that and disagreement, so.
I mean, if we get it before the end of the year, we could put it on the agenda for the 6th, talk about it, and then if we need to have a workshop, we can always do it the following week, right? So,
Okay,
Great.
I'm good with that.
I do feel confident that we'll have it by the end of next week, after talking to Michael here today.
Just a thought though, I mean, kind of a middle of the road of both is that I think there's enough there with the golf course. There's always been a lot on the golf course that to accommodate what Steve's saying is have a separate meeting just for golf once a month. And then everyone knows it's right after our regular meeting or it's right before. And we cover anything that needs to be covered just related to the golf course because it keeps it focused separately. And I think it's kind of important because there's so many things going on out there, even if nothing ever happens with it. Look what FP&L is doing out there. What are we going to do with the fencing out there? I think we've kind of rolled it into our normal book of business of everything, but I think for the purpose of homeowners and everyone else, it's helpful for them to know that there is a regular scheduled discussion about the golf course on the second one of the month or whenever it is, it's always there. And then it's isolated just to that, so that's their only topic, we can talk about it. And to me, it might fit. But just think about it, it's not saying we need to do anything now, it's something for next year.
Let's think about it. Thank you.
Anything else? I did not have anything else.
Okay. District Council, anything else?
Just briefly if I can, as a matter of disclosure, I'm going into some surgery on the 17th of December, some cervical spine surgery. So I'm gonna, it's not the first one I've had actually, it's called some cleanup work they gotta do. And I'm gonna be out for a little while from the organization. I will not see you in the January meetings, I'm not sure of that exactly. I won't be driving for a period of time because it's tough to drive with a neck brace, so it's also illegal to drive with a neck brace. Just want to let you know that you may see a little more of Jacob, a little less of me, but it's not because I'm out at a bowling tournament or doing beach volleyball, but it's a little surgical situation in Jackson. So.
We wish you well, Sam.
Thank you. Thank you very much. We're on the 17th, and hopefully I'll be home and recover and get to work and figure things out from there, but hopefully it'll be a good thing overall. So thank you for your listening, and in the interim, I certainly wish you a very happy holiday as things progress. Thank you for listening. Thank you for having me. Us.
Thank you. Commissioners, Mrs. Wright?
Nothing.
Okay, Steve?
I'm good.
Mr. Ernst?
Just one item, I think that, I wanted to address Rick Hurd's comments about relevance and the relevance of the district, and I don't agree with what he said. I think it is very relevant to the community. The community may not always see where revenue or where things get done, but it's still 25 million that does come in, and it does a lot of useful things. And over a long period of time, we preserved quite a bit of green space, and so I'm very proud of being part of this district board, and I think it's a terrific body that has done many good things. And I think we've also acted in a good way with the city, and the city has, they push back and we push back on them, but at the end of the day, we are a better entity for that, so I think it's been very good. Sometimes not always fun, but it is a good relationship, and that we're very relevant, and it's appropriate for the community.
Thank you.
I second Craig's motion about the relevance of the district. The things that we've done, it's just been, we need to let our light shine more so people know how relevant we are. And I think over the years we've started to do a better job about that. And I hope that we're able to continue to do that well past my tenure on this board. And I have nothing further.
I'm good too. So do we have any other future agenda items other than Brian's agreement, the ILA, and the banking RFP and communications?
We can actually put both of those on the agenda for the next meeting. Merv and I are gonna be interviewing the banks next week when he's back, and we'll hopefully have a recommendation at the next meeting, and I can talk to you about that
So I'm
separately.
confident in the commission's decision that
I'm confident in their decision.
Oh, just,
Mr. Engel, we need a motion.
okay, just one comment.
Okay.
I almost forgot. An early happy birthday to our chair, is what we'll say.
It's a big round one this year, you guys.
10, right?
10.
And on that note, move to adjourn.
Do I hear a second? All in favor, say aye.
Aye.
Motion passed. Who seconded it? Bob.